Miss Fabian. Who's Earl Major? Oh, is my, is it 11 o'clock? 2, please.
All right, folks, buckle up. This isn't just another day in court. What you're about to see is a mix of legal drama, high stakes, and a BAC reading that'll make your jaw drop. Question for you. Do you think treatment can outweigh punishment when someone's on their 3rd DUI? Let's find out.
Okay. All right. I'm going to call Mr. Majors first. It's just an amendment. He's prepaid what he needed to pay. We will go on the record in the matter 24 CM 105, 24 TR 581 and 582, State of Wisconsin versus Earl Major. All right. We will go on the record in the matter 24 CT 39, 24 TR 280, State of Wisconsin versus Eileen Fabian. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Fabian appears in person with counsel Joel Schlitz. We're set today for a plea and sentencing. I'm fully expecting that we are all good here today, Mr. Schlitz.
I believe we are, Your Honor.
Excellent. Plea, questionnaire, waiver of rights form, please.
May I approach?
You may. Thank you. Ms. Fabian, we have a plea questionnaire waiver of rights form here. Mr. Schlitz, she's pleading to the OWI 3rd. Can you, and it's for IDIP recommendations, is that correct?
That's correct, Your Honor.
All right. All other matters would be dismissed and read in or merged and dismissed, correct?
Yes.
Ms. Fabian, I have the plea questionnaire waiver of rights form in front of me. Do you recognize the document? You got to say yes or no, and
Yes.
Please have the microphone to you. We have a visiting court reporter who needs to hear everything, okay?
Yes,
And is that your signature on the second page?
yes,
It states that you are pleading guilty to 1 count of OWI 3rd. Is that correct?
yes,
Did your attorney go over this form with you thoroughly?
yes,
That is word for word?
yes,
Did you understand everything on this document?
yes,
You're 60 years old, you have 14 years of schooling, you can read, write, you understand the English language, no drugs, alcohol, or other medications in the last 24 hours, no receiving treatment for mental illness or disorder. Is that all correct and true?
yes,
You went over the charge with your attorney, what the state would have to prove, is that correct?
yes,
And your attorney went over with you the minimum and the maximum.
Notice how carefully the judge is walking through Fabian's rights here? This is called a plea colloquy. It's basically the court's way of making sure she understands every consequence of pleading guilty. Think of it like a legal safety net, because once you say guilty, there's no going back. Would you be this calm under questioning?
Possible penalties you face, is that correct?
yes,
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Your attorney went over these rights with you thoroughly, correct?
correct,
And you understand them completely?
yes,
Do you need me to go over those rights with you in any more detail?
no,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that here, the state would have to prove on or around March 10th, 2024 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a misdemeanor. Upon conviction, this would be a 3rd countable offense. If convicted, you face a fine of not less than $600, but no more than $2,000, an imprisonment of not less than 45 days, but no more than 1 year in the county jail. Do you understand that?
yes,
Plus, the court shall order you to complete an OWI assessment and driver safety plan, as well as revoking your driver's license for not less than 2 years, but no more than 3 years. Do you understand that?
yes,
Do you understand that the recommendation is for the court to follow the IDIP guidelines for sentencing? Do you understand that I don't necessarily have to do that?
Yes.
I could sentence you all the way up to the maximum possible penalties if I thought this case warranted it. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
All right. Now, did you go over the criminal complaint with your attorney?
Yes.
In particular, that section that's called the probable cause section that basically says what happened that day and why you were charged with crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant?
Yes.
And that would be your third countable offense.
Yes.
Mr. Schlitz, made the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes, I am.
Any questions for the court or for your attorney before I proceed?
Nope.
As to count 1, OWA 3rd in 24 CT 39, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the count. The other count in that case will be dismissed and merged in with count 1. The TR matters will be dismissed and read in. A judgment of conviction will be entered today. What was the BAC?
314.
All right. Argument and sentencing recommendation, Mr. Schmidt.
I think the IDIP program benefits both the rehabilitation of offenders and the public at large by encouraging people to do the assessments and some AODA and stuff before they even enter a plea. A lot of people, even though they get court ordered it, wind up not doing it. So it's better to protect the public. And that's why we have those guidelines.
And there it is, officially guilty. But here's the kicker. Her blood alcohol level was 0.314. For perspective, 0.08 is legally drunk. 0.3 is dangerously close to alcohol poisoning. Some people don't even stay conscious at that level. This isn't just bad decision-making, it's a brush with death.
Have those guidelines to incentivize that. The defendant's done that here. I think it's appropriate to follow them here. I think the 0.314 BAC is really scary. That's a borderline alcohol poisoning level. 0.4 is when it starts to get fatal. So I hope that she's benefited from the treatment. Thank you.
Thank you. Mr. Schlitz.
Thank you, Your Honor. There's nothing glamorous about what happened that day, Judge. She was out drinking and unexpectedly decided to leave and drive. She hit a curb on a roundabout and got a flat tire. She was cooperative with law enforcement, but pretty upset with herself for having made that decision. Following that day, Judge, she did her Rule 25 evaluation in the state of Minnesota as soon as she could. She enrolled in treatment when it became available. She's treating through intensive outpatient treatment 3 times a week. She enrolled in the IDIP program, or a similarly situated program with Ms. Anderson. Months ago, she's already completed 105 hours of community service. She's got 12 more shifts reserved. I've got an email from the Catholic Charities that she's been doing some service with. The court may or may not be aware that she's got a Minnesota driver's license, and the state of Minnesota effectively bars anyone from driving for the entire period of an out-of-state revocation. So this is going to have some pretty serious consequences for her. She lives in St. Paul. She's going to have to find a job that is along the light rail, because that's the only way she's going to be able to have, transportation. I think she's owned up to her poor choice that day, Judge. And she's ready to put this behind her and just kind of focus on trying to, maintain her sobriety one day at a time, Judge. As the court knows, nobody's perfect in that regard. But, I think that she's trying, and she's done just about everything that we could ask someone in her shoes to do. And I think that the the IDIP program is, you know, successful in that regard. And I think that, you know, it's certainly something that she's.
Her attorney's painting a picture here. Community service, treatment, no excuses. This is the classic defense strategy. Show rehabilitation to soften the blow. And honestly, she has put in the work. But the big question, should effort after the fact erase the danger she put others in?
Taken advantage of here, Judge.
All right, thank you, Mr. Schlitz. Ms. Fabian, anything you want to add or state for the court?
No, I'm good.
All right, thank you. Well, Ms. Fabian, this is that's a high BAC, 0.314. It's not the highest that I've seen in court here today, though, or not today, but in court at all. I think one of our highest was actually a 0.5 something. That's scary, and that somebody can actually live and walk around and have such a high blood alcohol content. A 0.314 is very telling about a few things, that probably something's been going on with you for a while, and that perhaps you do have substance abuse issues with alcohol. And I'm hoping that that's something that you're going to be able to address, and that you're working with a therapist, not just an AODA counselor, but an actual therapist, because it's telling me that you have some underlying trauma or issues that are having a significant impact on your ability to find peace and harmony in life. And I'm not asking for you to tell me what those are. I can just feel that that is what's going on. And so hopefully through this conviction, you'll be able to realize and have some self-reflection and be able to face that head on and to empower yourself in your life. And OWI is very serious. It's serious because, especially with the BAC at this high of a level, you could have been injured, you could have been killed, someone else could have been injured, someone else could have been killed. The fact that the community is at risk with all OWIs, for the most part, most OWIs. So they are serious. You did take steps right away to get your assessment, to try and do the programming that you need, and you're working very hard at doing all of that community service, which that is showing positive for you. And you're accepting the responsibility, and you are saying you're going to be accountable. And this is going to hurt you in terms of more than just another conviction or an OWI conviction. As your attorney stated, it's going to significantly impact your life in many different daily ways. But hopefully you'll be able to work through all of that, and hopefully you'll be on that path to recovery, body, mind, soul. I don't think that this is something where I need to go above and beyond the IDIP guidelines, because you did what you need to do, and you're learning the things, and you're trying to take control of your life and your drinking. Okay. So I think that because you went through the program, I think you should get the benefits of the IDIP guidelines. So what the court is going to do is I will assess $3,175 in fines and fees, 55 days of jail with 1 day of jail credit, 24 months of ignition interlock device, and 24 months of revocation of driver's license, 125 hours of community service. I will also note on the record you have 105 hours already completed, and so you just need to provide proof of that additional 20 hours to Ms. Anderson. And that needs to be done by the end of your sentence. I will grant you the ability to serve it on electronic monitor after the first 48 consecutive hours are sat.
So here's the sentence: jail time, ignition interlock, license revoked, community service, and a hefty fine. Strict but not maximum. The judge is clearly balancing accountability with hope for recovery. Now let me ask you, do you think this was fair? Or should the court have gone harder given her BAC? Drop your thoughts below.
But while on monitor, I'm going to tell you the monitor is very sensitive, and it takes a photo of you when you do your blows, so we know that it is in fact you. I'm going to tell you that if it blows positive, it blows hot, that there is any amount of alcohol from any source, even if it's a 0.0001, this court finds that as a violation. And so you will be told by Ms. Anderson that you are immediately revoked and you must immediately report to jail to serve the rest of your time in jail. No good time, no Hubert. So I will give you the cautions of do not have any rubbing alcohol on or around your face when you're going to blow or near your machine when you're going to blow. Do not have any food that's made with any real alcohol, no tiramisu, no bang bang shrimp, no bourbon shrimp, nothing of that nature, because it will set the machine off. No aerosols around the machine, it will set the machine off. This is strict compliance. You do not get a hearing to tell me, hey judge, it was really mouthwash. I do not allow that type of hearing, okay? So be very cautious, be very careful. And you must prepay at least 30 days at a time for your monitor at $18 a day. You will be permitted to go to the grocery store 1 time a week. You can go to AA. You can go to doctor's appointments. You can go to your community service. You can go to work. You cannot go to a birthday party. You cannot go to your niece's graduation. You cannot go to anything other than what is specifically laid out and told to you by Ms. Anderson. If something comes up and you have a death in the family and would like to go to the funeral, you need to, in writing, request that, and I will let you know if you are approved or denied. This is an in-home jail sentence, and so it is a punishment, and as such, it should be somewhat of a punishment. When do you believe that you would be able to pay off the fines and fees?
She probably wouldn't get payment plan, Your Honor.
All right, $500 a month to begin in October, and then $500 a month thereafter until paid off in full. If you experience a significant financial hardship and you do not believe that you would be able to cover that much every month, you need to fill out the financial form, file it with the court, and request a financial review hearing. I will go over all of your finances, all of your income, all of your expenses, and I'm going to tell you sometimes it actually goes in disfavor of the person requesting a reduction in the amount. The court has actually sometimes raised that amount based upon the information that I have been provided.
Your Honor, I didn't mean to interrupt you, I'm sorry. I can provide some information to the court that she is not currently employed.
And that's not my problem. She
Okay.
has to figure that out. This is a penalty, and it should be a penalty. It is a consequence of her actions. But again, if she's unable to figure that out, that's where she would need to have a hearing in front of the court. I need your DNA. You're going to provide that in the jail. It's immediate report. So once you're done here, you're going to leave this building, go all the way around and report to the jail for your sentence. Ms. Anderson will be there to hook you on the monitor at her earliest convenience. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You can request to have your DNA expunged from the system through a written letter to the Department of Justice. It's easy, Google it, or your attorney can tell you how to do it. If you don't pay your fines and fees, not only will a civil judgment be entered against you because you're always going to owe it, but the court will issue a warrant. You could sit up to 6 months in jail. It's very important you figure out how to pay that off. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Schlitz.
Credit for any administrative suspension, Your Honor.
She can have credit for any administrative suspension she has received. All
Thank you.
right, thank you. Then we are adjourned. Immediately report, and they will take your DNA, and you will be good to go.
Thank you, Judge.
Connie and Mr. Schlitz, I'm going to take a 5-minute break. We'll be right back to hear the other case. All right.